I'm Assistant Professor Kritika Dev from LJ School of Law. Today we'll be dealing with Indian Evidence Act, and under it we'll be dealing with the documentary evidence. I hope you remember what happened in the last class. In the last class we were dealing with the oral evidence, and of course that is the reason I always ask you to revise in order to get clear idea whenever I come up with new sessions. So today we'll be dealing with documentary evidence. When it comes to documentary evidence, I have divided the sessions in two parts, part 1 and part 2. And of course, today we are dealing with part 1 of the documentary evidence. So before going to the specifications, the specific definition, let's see the importance of documentary evidence. So when it comes to the kinds of evidence, and when once you go for the oral evidence, and of course when it comes to the oral evidence, the eyewitness evidence is direct, and of course it is admissible, and the whole judgment of the court can completely rely upon that one witness. But when it comes to the importance of documentary evidence in the civil matters, it becomes far more better than any other evidence, because you have the document itself in order to prove your statement, or in order to prove whatever is being pleaded by you in front of the honorable court. So of course it has a good weightage when it comes to the evidence. If something is being proved by the document itself, it has a good weightage in front of the honorable court. So here let's see what is a documentary evidence and what can be proved and how can they be proved. So when it comes to the documentary evidence, proof of contents of documents. You remember in the oral evidence we have read that everything except the contents of the documents or the electronic record can be proved by oral evidence. So that exception is now here a section that contents of the documents may be proved either by primary evidence or the secondary evidence, right? So the contents of the document, it can be proved by primary evidence or the secondary evidence. Now let's quickly see what primary evidence is all about. So here, when we talk about the primary evidence is mentioned under section 62 of the Indian Evidence Act. Now what the section reads: primary evidence means the document itself produced for the inspection of the court. Now for say if the whole dispute is behind that very property document or that very will or anything of that sort, any written document. Now if the document itself is produced before the honorable court, what could be a better evidence than that? Then that is the primary evidence. Now there are two explanations which are given under this section. Now the explanation 1 reads that where a document is executed in several parts, each part is a primary evidence of the document, right? So when it comes to a document which is executed in several parts, right? A document which is executed in several parts, then each part of that very document is a primary evidence. Let's take an example. First, say that there is a contract between A and B. And now here, the contract has, because every party wants to have the whole document and the original contract with them, the original document and the original contract with them, in order to have the clear idea about it and of course to be at a safe side. Now, the document has been executed in two parts only from the very beginning, both the documents having signs of both the parties. Now the document from the very beginning was executed or was there in several parts, and in this case in two parts. Now both the parts, whether A is having it or B is having it, is the original document, will be considered as the primary evidence here, right? Okay, now that under the explanation we can see where a document is executed in counterpart, each counterpart being executed by one or some of the parties only, each counterpart is a primary evidence as against the party executing it. So in order to make this thing very clear, let me give you one very simple example. If you go to a bank, right, when it comes to you depositing some amount, and there you always sign that very paper, that very slip, now signed by you, is being kept by the bank, and the stamp or signed by the bank, the stamp of the bank, that very slip is been given to you. Now, this has been executed in counterparts, means thing which was executed by the bank is with you, and which was executed by you, where you put your signature, yeah, these were the notes and this was the amount, is there with the bank. So now they are the counterparts executed, and you having the executed part which was executed by the bank, and bank has the part which was executed by you. Now they both are the primary evidence. If the bank is at fault, I can show it to the court, because I have the executed portion which was executed by the bank. If I'm at fault, the bank can show the portion which was executed by me, right? Then both are the primary evidences. I hope this is very clear with this simple example. Now, the second explanation says where a number of documents are all made by one uniform process. As in the case of printing, lithography, or photography, you see one uniform procedure is being followed when it comes to printing. So each is primary evidence or the content of the rest, because they're all being processed by one uniform process, right? So that is the reason each of them is the primary evidence of the contents of another. Any of them can be produced when it comes to the contents of another, right? Okay. Now, what do we understand by secondary evidence? Primary evidence, of course, in every case we would love to give the primary evidence, but what if the secondary, we cannot get the primary evidence? Now, the second thing would be the secondary evidence. Now, let's take an example of the certified copies, right? When it comes to any document, if you do not have the original document, you can get the certified copies of it. For say some of the government documents, you cannot get the document by themselves. So you can prove your document through the certified copies of that very original document, or copies made from original by mechanical process, right? So what will happen under this? So in this, the original copy is there, and you are taking the photocopy of that through the mechanical process. You get the photocopies of many of your documents, right? So those photocopies of that original document, now these photocopies are what? These are the secondary evidences. So these photocopies will be taken as the secondary evidence because they are being done through a mechanical process. Now, copies made or compared from the original. Now, what do we understand by it? Two things are there: copies made or compared from the original. If something is written and you have copied it, by seeing the original, you have copied it. Now, that copied document will be known as the secondary evidence, because the original is there, but you have compared it completely with the original and you have written it. Then that written document which you have compared will be known as the secondary evidence. Now, counterparts of the documents against the party who did not execute it. You remember the bank example that we have taken just now? So now in the same example, if you would have had your own copy, in the example, what did we see? That thing, the paper on which my sign was there, when I went to withdraw the money, my sign was there. Then the signed by me, that paper was there with the bank, and signed by the bank, that paper was there with me. But if it had been with the respective people only, I would have had the mine one, and the court would have had the side of paper which was executed by it. Then me having mine, the bank having his own, will be termed as the secondary evidence, because we must have had the counterparts of each other, the previous one, but here we have the same ones which was executed by us only, right? Then it will be taken as the secondary evidence. Now, the last one is oral accounts of documents by a person who has seen it himself. Now, we had seen that when it comes to the documents, the oral evidence is not acceptable. But here is this very exception that you can say, that if the oral accounts, if for example, let's take an example, if it comes to any document, any paper, any property paper, or anything, any will maybe, right? Now, if it is in dispute and here I come and I say I had seen that person write, and in the will it was written that this property will go to him, that property will go to him, right? Because I say in front of the honorable court that I had seen that person write. So of course contents cannot be proved, but because I had seen that person write the contents, then my oral evidence will be taken here with respect to the contents of the document as the secondary evidence, right? So this is all about the primary evidence and the secondary evidence. I hope everything is clear till now, the primary evidence and the secondary evidence. And of course, we have part 2 of the session, which have the detailed version of it, that you will get to know when you'll see the part 2 of this very session. Till then, keep studying and keep revising. Take care. Thank you so much.